Welcome. In today's session, we will continue with the previous points we have discussed. So, till now, we have discussed about intellectual property, patents, design, trades, and copyright, and the different types of intellectual property we have seen, that is industrial design, patents, trademarks, trade secrets. So, these 4 points we have seen. Today, we will see geographical indications and layout designs of semiconductor ICs. So, geographical indications is an indication originating from a definite geographical territory and used to identify agricultural, natural, or manufactured goods. The manufactured goods should be produced or processed or prepared in that territory. So, geographical indicators indicate indications are Nagpur is famous for ranges. Kolhapur is famous for chappals, Kolhapuri chappal. Solapur is famous for Solapuri chadar. So likewise, these things comes under geographical indication. So these should have a special quantity, quality or reputation. These should have special quality or reputation or other characteristics. For example, Gadwal, Pochampalli, Kanchipuram silk sarees, Paithani sarees, Nirmal paintings, then Bainginpalli mangoes, Alfonso mangoes from Ratnagiri, then Darjeeling tea, Kolhapuri chappal, Solapur chadar, even Tirupati laddus, Nagpur oranges, Bikaneri bhujia. So all these falls medical indications, GIs. So these are registered that to confer legal protection in India through the geographical indications of Goods Registrations and Protection Act of 1999. It prevents unauthorized use of registered GI, promote the economic prosperity of the producers of goods produced in geographical territory, which in turn boost exports. So these are used to do the business and it boosts the exports from that particular territory. So GIs will protect the producers or manufacturers of that particular geographical territory. That is the importance. Now, who can be the owner of these geographical indications? So it may be any associations or association of persons, producers, organizations or authority established by the established by or under the law representing the interest of the producers can apply for registrations. So again, we knew that some like Mumbai's vada pav, Pune's misal, Nagpur's haldiram sweets, and all these different are falls under geographical indications. And the producers can apply for registrations of GI to the registrar of GI in the prescribed format, along with the prescribed fee, whatever format is given, and with the prescribed fee, they can apply for it. A producer of goods can apply for registration as an authorized user of registered GI. The person or the entity which produces those goods from that particular territory, they can register for the GI. Producer in case of agricultural goods means a person engaged in the production, processing, trading, or dealing in such goods. In case of natural goods, a person engaged in trading or dealing. And In case of handicrafts or industrial goods, a person engaged in making, manufacturing, trading, or dealing in such goods. So these are the producers. An authorized user has the exclusive rights to the use of geographical indications in relation to registered goods. And generally in India, the registration of GI is valid for 10 years. So we have seen for different points, the different duration of validity is there. So for GIs, it is 10 years and can be renewed from time to time for a further period of 10 years. So renewing is also possible and it is for the next 10 years. A registered GI is public property belonging to the producers or of the concerned goods, and hence it cannot be assigned or transmitted or licensed or pledged to mortgaged. So what are the infringements? When an unauthorized user uses this GI that indicates or suggests that such goods originate in geographical area other than the true place of origin of such goods in a manner which mislead the public as to the geographical origin of such goods. So if thing happens, then it leads to infringement. When the use of a GI result unfair competition, including passing off in respect of registered GI, or when the use of another GI results in false representation to the public that goods originate in a territory in respect of which registered GI relates, it continues infringement. If you mislead or uh, uh, gives false representation, then that also leads to the infringement. The registered proprietor or authorized users of a registered GI can initiate infringement action against the one who uses these GIs. Now the last one is layout designs of semiconductor ICs, integrated circuits. It provides protection for semiconductor ICs, layout design. So this provides semiconductor IC layout designs. India has now in place Semiconductor Integrated Circuit Layout Design Act 2000. So this is the act which is currently in India. That is Semiconductor Integrated Circuits Layout Design Act 2000. To give the protection to IC layout design, layout design includes layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in any manner in a semiconductor IC. So generally it is having semiconductor IC is a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. And again, here the semiconductor design IC's registration is applicable or valid for 10 years from the date of filling. And IC layout design cannot be registered if it is not original. So remember, if the design is not original, then you cannot register it. First thing. Second thing, commercially exploited anywhere in India or in any convention country. So if it is already commercially exploited in India, then it is also cannot be registered. Or third one is inherently not distinctive. So if it is not distinctive than the existing systems, existing ICs layouts, it cannot be registered. Inherently not capable of being distinguishable from any other registered layout design. So it if it is not distinguishable, then also it is not registered. It cannot be registered. And designs not exploited commercially for more than 2 years from the date of registration of application shall be treated as commercially exploited for the purpose of this act. So this is one point to be noted. Again, when it is applicable, reproducing, importing, selling, distributing the IC layout design for commercial purposes only constitutes infringement. So, if some registered semiconductor layout is there, and if some other person reproduces, imports, sells, distributes that layout design for commercial purpose, then it leads to the infringement. A person when creates another layout design on the basis of scientific evaluation of registered layout design shall not be causing any infringement. If you have designed using scientific evaluation, then it was. So all these things in brief we can see here. So initially we have seen industrial design, that is it. Industrial designs are the features, shapes, patterns applied to any article by an industrial process. Chair, door, pen, all these are the industrial designs. Then second one we have seen is patents. So patent is a monopoly right granted to a person who invented a new product or process of making an article, and the duration of or validity is 20 years in under the Indian Patent Act 1970, and can be renewed after expiration period. The inventor has to file for patent first and then make his or her invention to the public. So one cannot make it public in prior before filing the patent. Then next one we have discussed is trademarks. It can be a word, name, brand, symbol used by a company to create a unique identity for that product. Trademark can be registered and then use TMR. The registration validity is for 7 years and renewable after expiry. In India, it is governed by the Trade and Merchandise Marks Act 1958, which came into force in 25th 1959. After trademarks, we discussed trade secrets. So it is an intellectual work or product used for business purpose that can be classified as belonging to that business, provided it is not based on the information in public domain. Then just now we have discussed about geographical indications, that is the product or process originated from geography or geographical area. For example, Nirmal paintings, Kolhapuri chappals, Paithani sarees, etc. And copyright we have seen, it is a negative right which prevents the appropriation of the fruits of man's work, labor or skills by another persons. So it may consist of dramas, music, choreography, chromatography. So Bhagavad Gita, Patanjali Yoga Sutras, Narad Niti, these all comes under copyright. So here are a couple of examples of IPR's infringement. So first one is a student of US University was accused of infringing intellectual property rights after illegally downloading songs from the internet and sharing them with others. He was found guilty and ordered to pay 4 business safety damages of US dollars 675,000. And student was accused of downloading 30 songs from the internet and sharing them with the friends. According to the US federal law, the victim may demand damages ranging from US dollar 750 to US dollar 30,000 for each song infringed upon. So the point is here the student of US University has downloaded songs from the internet illegally, and that has costed him a hefty penalty. Then a graduate student in Taiwan University uploaded publications of domestic publisher onto his website for downloading without authorization or consent. The authorities were soon informed and the student was prosecuted and convinced of copyright infringement. So you cannot upload someone others books, articles or papers as if it is yours without their consent. So all those falls under copyright infringement, and this is nothing but the IPR infringement. So you can see such more studies at different examples given in these links. So you can study that. Now we will some point discuss about some points related to the international organizations in intellectual property. So there are two mainly bodies. One is World Intellectual Property Organization, that is WIPO, and World Technology Licensing Organization. So here the important thing is IPR licensing and technology transfer. So what do you mean by licensing of an IP? License is a permission granted by an IP owner to another person to use the IP on agreed terms and conditions, while he continues to retain the ownership of the IP. Suppose if you have patented some product and some other person is willing to use your product for his applications, then he or she can take permission from you, and then they can use for it, and some support is given to you, but at the end the ownership of that particular product is with you only, and that process is known as licensing. So licensing creates an income source. That's what I mentioned. The when you are giving your product to use to other person, that person will give you some monetary benefits. That is nothing but the income source. It establishes a legal framework for transfer of technology to wider group of researchers and engineers. It creates market presence for the technology or trademarks. Licensing conditions for IPRs are owners of IP prefer to transfer technology through licensing agreements only. So owners of IP prefer to transfer the technology through licensing agreements. All rights or limited rights can be licensed. So whatever rights or limited rights can be licensed through licensed technology. It can be exclusive or non-exclusive or sole depending on the owner and the license. Most such agreements provide for royalty payment and non-transfer to a third party. Royalties can be upfront, part upfront, and part percentage per production per sale, only percentage per production per sale. The particular use of for which the IP can be used are also generally specified. These needs to be careful about the competition law. Now, there may be a question that licensing is profitable. So you can see examples given here. IBM revenue from patent licensing around $1.7 billion in 2002. So this is from 21 years ago. $1.7 billion from the patent licensing. Texas Instrument, all we know that it is leading organizations in embedded and DSPs, controllers, devices. It, it gets $3 billion in licensing in 10 years. Then US and Canadian universities generated $1.1 billion in royalties in 2001. New York University's revenue from the licensing is $109 million in 2004. Ohio University to get $52 million from royalties on the growth of hormone drug. Then CSIR gets almost $150 million as royalty. So you can see from this that what is the importance and significance of licensing, and you can conclude whether licensing is profitable or not. Now, procedures for grants of patents. The procedure for granting patents may vary depending on the country or region where the patent is being sought. So it depends on the regions and territory. Here are the some general steps involved in patent granting process. So this is important. Patent granting process. So first step is invention disclosure. So the first step is to conceive and develop a new invention or innovation. Once you have an invention, you should document it in details. So if you have identified or innovated, got an idea about innovation, then you should document it, including its technical features, purpose, and any associated drawings or diagrams. Second is prior art search. Before proceeding with the patent application, it's advisable to conduct a prior art search to determine if your invention is novel or non-obvious, non-novel and non-obvious. So it will help you in finding out if there is any such existing product or process or service. Third one is patent application. So once you do the invention and do the literature review or prior art search, third step is patent application. That is, prepare a patent application that includes written description of your invention, claims that define the scope of your invention, and any necessary drawings or diagrams. The application should meet the specific requirements. Afterwards, filling the application, that is, submit the patent application to the appropriate patent office along with the required filling fees. So you need to pay the fees to the uh, patent office. The application is assigned to filling date which establishes priority of your for your invention. Then next step is formal examination. Once your application is filled, it goes through a formal examination process, and the patent office reviews the application for compliance with formal requirements such as proper documentation, payment of fees, and adherence to any specific rules or guidelines. Next step is substantive examination. So in this stage, patent office evaluates the patentability of your invention, and the examination typically involves a review of the prior art assessments of the novelty and non-obviousness of your invention. Then next step is office action and responses. That is, during the examination, the patent office may issue one or more office actions, which are official communications that outline any objections, rejections, or requirements for the amendment. And the next step is grant or refusal. If the patent office is satisfied with the patentability of your invention and of the product or service, and all the formalities have been met, they will issue a patent grant. That means your grant is success or it is granted, your patent is granted. And if they feel that it is not adequate, non-obvious, or not innovative, then they may give the refusal. Then next is, or the last is maintenance and renewal. After the patent is granted, you must maintain it by paying the required maintenance fee or annuities to the patent office at specified intervals. And failure to pay these fees may result in the expiration or abandonment of the patent. So this is again important. So you need to pay the fees at the specified intervals. So these are the 9 steps. That is invention disclosure, prior art search, patent application, filling the application, formal examination, substantive examination, office actions and responses, and then grant or refusal, and maintenance and renewal fee payments. Now, at international level, there is one treaty, that is Patent Cooperation Treaty (PCT). It provides us with an overview of an international treaty which is duly administered by the World Intellectual Property Organizations. So that is WIPO, the World Intellectual Property Organization. And the Patent Cooperation Treaty, it is an international treaty with more than 148 contracting states. And it is an international treaty which provides a system for filling a patent application and allows us to obtain the patents in multiple countries around the world on the basis of a single patent application. So it is not required to patent in each and every country. So if you patent through patent cooperation treaty in one single application, it is applicable to the multiple countries. As PCT simplifies the procedure for obtaining patent protection in many countries, making it more efficient and economical. So you will not have to bear application and all other fees at every country. Only once you can uh, pay, or you need to adhere the cost through single patent application. It uses of the patent system, and it is users of the patent system, that is an applicant and inventors and national offices also, it is useful, and therefore it is efficient and economical. It simplifies the patent filing process. That's important. So it's the process for applicant, and the ultimate decision to grant a patent vests exclusively with each national or regional patent office. And a single PCT application has the same legal effect as a national patent application in each of the PCT contracting states. Without PCT, we would have to file a separate patent application in each country separately and independently, and everywhere we need to pay the fees, and that is not efficient and not economical also. Again, what are the advantages? It saves time, efforts, and expense of preparing the separate application forms and all this. In various languages also, as the country varies, it may be possible that the languages at in that particular country is different. So PCT, file an application under the PCT directly or within the 12-month period as provided by the Paris Convention form the billing date of the first application, which is valid in all contracting states of the PCT. So it is valid in all the contracting states. What is the need of PCT? It provides users with a worldwide system for the simplified and effective filling of the patent application. So that is the need. To bring the world within the reach for any innovator or researcher, it brings the world within the reach. It removes major costs as well as provides users with additional time to consider their various patent granting options. It provides strong basis to the user for patenting decisions. It is effectively used by the world's major corporations, universities, and research institutions when they seek international patent protection. What are the basic features? Formal examination done by one office. Retrieval is carried out by one office. International publication done by the one office. Examination and authorization finished by the national office. Simple single application with legal effect in all the PCT countries, that is 148 countries, and 4 regional patent systems. So these are some major or the fundamental features of the PCT. Then the advantages. This is, as an international patent system, it provides worldwide system in a simplified filling application form, processing of the patent application with, and helps. So a single application in a single language filled in a single country called the international application. It provides strong basis for patenting decisions to the users also. Then it harmonizes formal requirements used by the world's major corporations, universities, and research institutions. Single application has the effect of filing simultaneously in different countries or whatever designated countries, 148 countries. It protects applicant from certain inadvertent errors, evolves to meet user needs. So again, we'll see some processes of PCT filling. So first step is filling of local application. So whenever an innovator wants to file a patent under PCT, he or she has to first need to file a patent in the home country. That is at the local, one needs to file the local application. Then fill the PCT application. Applicant needs to file a national application along with international application in one language and need to pay the single set of fee. So this is important. Single set of fee. You need not require to pay for local and international applications. Only one set of fee you need to pay. PCT application is to be filled within 12 months after filing a national application. Then PCT application can also be directly filed to RO, that is receiving office within the WIPO organizations. Then the third step is checking for defects, and this check is conducted by the receiving office, and it is again divided into two parts. The first part concerns the requirement according to international filling date as set out in the Article 11 of 1 of PCT, and the second part concerns the formal and physical requirements under Article 14. The step 4 is international search report. So application is transmitted to an international searching authority, and an international searching authority search an application and check for a prior art and state of the art. So it finds out if there is any existing system or existing product services is available. They establish it on the basis of written opinions within 16 months from the date of filling. That is international search report will give search report with written opinion. Next step is international publication. So after submitting the necessary document, user application is published after the completion of 18 months. Before that, an application is kept secret. International Bureau, that is IB of WIPO, publishes the PCT application. And the step 6 is international search. Request for supplementary search is filled by the application before completion of 19 months from the priority date. So under this, the applicant demands for the international preliminary examinations. And seventh step is international preliminary report. So search authority will give report on patentability, whether or not patent is to be granted, and this is to be given within 28 months by the competent authority. And last or eighth step is enter in the national phase. After completion of all the necessary requirements, patent is granted by national office, and likewise patent is granted for in all other contracting states, and it is granted to the applicant before the completion of 30 months. So once you have applied, so before completion of 30 months, it is granted or refused. After this, applicant can seek the protection. So here is the filling process, that is from 0 months after uh, filing the local patent file. Within 30 months, you will get the PCT form. So you can see here, it is summarized in this picture. Inventions, then international application at filled with the receiving offices, then it is transmit applications to WIPO and international authorities, and from the international authorities it carry out search and prepare the written opinions, and it sends to the WIPO, and once WIPO verifies it, it publishes on patent scope and it communicates to the designated office, and from the designated office the patents are granted, and this total duration is 30 months. So you can see here 0th month application filed with the patent office on the priority date. Then within the 12 months, international application filled with the PCT receiving office. So within 12 months, we need to fill it with the PCT officer. Then at the end of 16 months, transmit of ISR and written opinions. And then within the next 2 months, publication of an international application, ISR and written opinions are given. Then applicant requires supplement international search up to within 22 months from the date of application. Then transmittal of IR, IPRP or SISR within the 28 months from the filing date. And then PCT national phase entry where the applicant seeks the protection is granted within the 30 months from the application of the patent. Now we have seen the features and advantages of patent cooperation trade. There are some disadvantages also. So while the treaty provides uniform formality requirements, international searches, and a centralized international publication system, the treaty procedures also come with certain disadvantages or limitations. So what are those? First, the system only facilitates the registration of utility patents and not design related patents. So it concerns about utility patents, not about the design related patent. Second point is PCT system is considered as an expensive process because it we've seen it takes almost 30 months, that means 2.5 years, since the application is prosecuted in each national and regional patent office separately. In addition to the costs incurred by the applicant to the prosecute the application in each national or regional office, the applicant has to also pay for the attorney fee in the international phase. So one has to pay the attorney fee. However, the benefits of PCT outweigh the negligible disadvantages it comes with. So these are some negligible disadvantages, but the advantages of PCT are far better, far more than these disadvantages. And it simplifies the process of filling the patent in multiple countries. So it has also fueled the spread of technological developments in an international scales in the last few years. So this is all about the intellectual property and IPR copyrights. So you can, for more information, you can read on this. You can go to these links and find out the theory about these points. So likewise, we have discussed mainly on these points. We started with copyrights and related rights. It is music, drama, and literary. Then industrial property. In that we have seen industrial designs, patents, trademarks, trade secrets, service marks. And in this session we discussed geographical indications, then layout of designs of semiconductor ICs, then international organizations of IP, and then at the end we have concluded with PCT, features of PCT, advantages of PCT, and few negligible disadvantages also we have discussed. So this ends our unit 4, that is nature of intellectual property. In the next session, we'll discuss some more points related with the patents, registrations, and granting of it. Thank you. So you can read more about these points through the PPT as well as the links provided at the end in the reference. And you can also refer the handbooks of the government organizations. So there are government handbooks based on the IPRs, that is intellectual property rights, and all the clauses points discussed in those handbooks. So in next session, we will discuss about scope of patent rights, then licensing point. We have seen some couple of points on about licensing and transfer technologies. Then also geographical indications and patent information and databases. So our main focus will be scope of patent rights and patent information and database. And our last chapter includes new developments in the IPR. So those points we will discuss in the next couple of lectures. Thank you.